All right. Good afternoon and welcome to the National Hispanic Cannabis Council's webinar on the New York regulations. This is the second webinar that we've had on New York's regulations, the first one since we've had full draft regulations, which is very exciting. My name is Jennifer Cabrera. I am with the law firm Vicente Cederberg, and I'm a member of the Board of Directors and Legal Committee for the National Hispanic Cannabis Council. And a really quick introduction to our organization. It is a nonprofit educational organization advocating for the education and inclusion of Latinos in the cannabis industry. So I invite you to look us up, join our national organization or our local chapter, the first one, which is located in the tri-state area. Let's say New York, but we call it tri-state. So anyway, we have a great program for you here today, and we are joined by a really stellar cast for this roundtable. First, we have Damien Fagan, the Chief Equity Officer for the New York Office of Cannabis Management, which is fantastic. Thank you so much for being here, Damien. Can I turn it over to you you can introduce yourself?
Hey, great to be here. Thanks for having me. It's an important conversation, getting this community involved and up to speed on everything with the regulations. We just entered public comment period today, so it's time to start generating that input, and we're going to start soliciting some feedback from the community, and your voice matters. Thanks for having me.
Awesome. Thank you, Damien. Next up is Fatima Afia, lawyer with Hiller PC. Fatima, welcome.
Hi, everybody. Thank you so much for that intro, Jen, and thank you all for having me today. I'm an attorney at Hiller PC, which is a firm in New York City. I've been practicing in the cannabis space since about 2017, first as a litigator and now as a transactional lawyer and advocate. I've advocated in places like Massachusetts for social equity initiatives, and I do a lot of licensing and regulatory compliance work here in the space, and I'm really excited to be here.
Wonderful. Thank you for joining us. Next up is Osbert Orduña, the principal and owner of the Cannabis Place. Osbert.
Hello, good afternoon, everyone. Osbert Orduña. I am, first and foremost for this call, I am the co-chair of the National Hispanic Cannabis Council Tri-State Chapter, New York, New Jersey, Connecticut. Check us out. Social media is nhcc.tristate. That's our Instagram handle. I am also the CEO and founder of the Cannabis Place. We are a service-disabled veteran-owned business and also a minority-owned business. We are currently pursuing licensing both in the New Jersey and New York area, and we're happy to be here and happy to be a part of this conversation and, of course, of the NHCC. So thank you.
Wonderful. Welcome. And last but not least, we have Daisy Morales, who is the Chief Operating Officer for Medley. Welcome, Daisy.
Hi, welcome. Thank you for having me. I'm very humbled to be a part of this panel today. My name is Daisy. I am the COO of Medley. We are a service provider in New York City. I had very humble beginnings by starting my own edibles brand a few years back when I first landed in New York State about 5 years ago. And it was then that I saw the possibility of being able to scale in cannabis. So I'm very excited to be a part of this conversation today. I am also a member of NHCC, and I highly recommend anyone that's thinking about joining to please participate and join our New York State chapter.
Well, thank you, Daisy. And it's great to be here moderating today. As I mentioned, this live session is presented by the Legal Committee of the National Hispanic Cannabis Council. Our mission is to educate the U.S. Hispanic Latino community on the health, wellness, and economic aspects of cannabis to empower their support and participation in the industry. So let's dive in. First, going to turn it over to Damien Fagan, because we're very excited that he's come and joined us here today and that the OCM is prioritizing this community in New York and this outreach. So Damien, you're going to educate us a bit on the current state of cannabis in New York and the new regulations.
Yes, I am. As soon as I can figure out how to share my screen. Why is it not showing up now? Here we go. All right. So how does it look? Are we good? Full screen? Okay.
Looks good.
Okay, great. Muy buenos días, todos y todas. Mi nombre es Damián. I am the Chief Equity Officer, as I said before. I'm happy to be here today to be talking to this group. It is my job as Chief Equity Officer to ensure that the office here in New York, we live up to the high ideals of the MRTA that lays out, specific guidelines to reaching 50% social equity licensure, incubators, grants to support those licensees, and to see the diversity of our state, particularly here in New York City, where I'm at now, represented in our legal cannabis industry. And so for this opening presentation, this is going to be a quick and dirty look at one specific aspect of the industry that we're building here that I want people to start becoming familiar with, particularly social equity applicants, because this is a defining characteristic of our marketplace, and also will lay out the pathway and access points for entrepreneurs. So first and foremost, today is December 14th. Our regulations were posted to the public registrar in New York State today. So that kicked off the public comment period. The first public comment period is 60 days. And so for the next 60 days, we will be receiving feedback from people from all over the country, all over the world, really, about what's in those regulations. 280 pages of, very precise regulations of the marketplace we want to build. It's not perfect. It only becomes perfect if we get great targeted feedback from folks. And I'm talking about, what is it about the cooperative license that's not going to work for you, someone who's experienced in cooperatives? Why is this, financial restriction on horizontal investments necessary? Explain what we got wrong. And we, as a team, we're expecting thousands of these comments to come in. We have a legal mandate to respond to them, and to and see what we can incorporate and what we can't. And so please take a look at those regulations if you haven't, start reading them. So our proposed social and economic equity regulations, my team authored a lot of this. It's not anything that isn't already in the MRTA. We're legally mandated to prioritize specific groups for licensure and also for technical assistance, grants, loans, what have you. We will also be waiving, deferring, or reducing application fees. We have some of the lowest application fees in the country, $7,000 a year for a dispensary license. For social equity applicants, that'll be $3,500. We also have the ability to defer those fees until the point the social equity applicant opens up their store and generates some revenue. We don't want fees to be a barrier to accessing this opportunity. And so we have a lot of ability to waive and move those fees around to ease access. As you can see here, minority-owned businesses, Hispanic-owned businesses are part of that social equity group that we will be prioritizing for technical support and assistance. Something important to communicate to this group: we are limited in our ability to use gender and race as prioritization in terms of business licensing. So, we have other categories such as communities disproportionately impacted, individuals with marijuana arrests that, may or may not be a pathway to improving access to those communities, those minority communities. But as far as a standard for prioritizing and licensure, it will not be that, but they will receive support from our office in terms of technical assistance, loans, and grants. So most important defining feature of our marketplace is our prohibition on vertical integration. Probably the most surprising to some. Those folks who were surprised, I guess, didn't read the MRTA, because we're legally mandated to have a two-tier system. Our cannabis law, took a lot of input from the SLA, the State Liquor Authority here in New York, that also has a two-tier system. It was also partly written by someone who helped write Washington's cannabis law. And so we took a lot of inspiration from the SLA and from Washington State in the drafting of our cannabis law and our regulations. So we believe our tiered system here that separates retailers from suppliers will support small businesses and promote fair and equal competition across the supply chain. We are, limiting the individual's ability to have direct or indirect interest within both of those tiers, and licensees will have to disclose partner individuals or entities with a financial interest in their applications, in their licenses. Vertical integration, what is it? Very simply, it's in every other state except Washington State right now. that allows businesses to move across these tiers from seed to sale and operate a vertically integrated business. In some states, it's mandated that you actually be vertically integrated. And so in some cases, you might need $10 million just to enter the industry. And that $10 million would build out your grow, build out your manufacturing facility, build out your distribution, and build out your retail all at the same time within the same year. We always saw that as a huge barrier for minority communities and for communities disproportionately impacted. And it also limits consumer choice in a lot of ways. A statistic that jumped out to us when we were drafting our regulations, Washington state dispensaries on average have 1,700 different SKUs, products in each dispensary. Vertically integrated medical cannabis companies, dispensaries in Florida, it's a medical industry, but it still sort of operates like a rec industry, 70 products per store. And so we, as New Yorkers, we've already had a diversity of product choice in the gray market, in the illicit market, and we want to replicate that in our legal market. That's the only way we're going to get people to cross over. Skip through that. So here's our tiered system. Here are the license types and where they're located on those two tiers. Obviously, we have our medical ROs who are vertically integrated as laid out in the MRTA, will eventually be vertically integrated. So they are a separate license type outside of this tiered system. Labs also exist outside of this. And there will also be restrictions on licensees having direct or indirect interest in laboratories as well to prevent any undue influence. So the benefits are a tiered market structure, very, very simply, homegrown and diverse brands, similar to alcohol, looking at the alcohol industry and seeing that people are still starting craft beer companies, still starting wine companies, still opening up wine shops 100 years after Prohibition is an indication of a healthy market architecture. We believe that's going to increase competition, fair competition between brands, between businesses, reduce barriers to entry and avoid monopolistic practices. Consumers will have more choice. Essential to our success in New York is providing that choice, extending that to a sophisticated marketplace where people already have that consumer choice. It also promotes research. It will challenge people to specialize in growing, manufacturing, distribution, delivery, retail. It'll force them to specialize in ways that we believe are going to lead to a lot of innovation in the space. True parties of interest. I definitely want people to become familiar with what TPI is and what it means. I won't go into too much detail right now, but this is the tool that we will use to protect the integrity of the two-tier system. This is essentially ensuring that people who have a financial interest in one company do not use financial interest they have over other companies to influence market behavior in anti-competitive ways. Please read into that. It's important that you guys understand it. These are all the individuals who would qualify as a TPI in your business when you apply. If they have any control over the operations of the business, they become a TPI and they're restricted from crossing over to another tier. There are horizontal restrictions as well. I know some states like license stacking or don't have any horizontal restrictions. We've seen how that leads to anti-competitive behavior, loss leaders, crowding out the marketplace, hurting small business. And so these are the restrictions and how many licenses you can have a controlling interest in. So you can have a controlling interest in up to 3 dispensaries, 1 cultivator, 1 delivery. So the numbers are all there. That's also in our regs. I'm going to stop soon because I know we have saved some time from Q&A afterwards. And I don't want to take up too much time with the intro, but TPI will also include people with a financial interest in the success of the business. So if the more you sell, the more they make, that is something that would, qualify you as a TPI. And here are, it's 10% of annual revenue, 50% of net profits, or meeting the threshold of $100,000 in a given calendar year. The last thing I'll say, passive investor, we do make space for passive investors to get money, deploy capital into our market. You can, for example, if we have 150 card dispensaries across the state, as a passive investor, you can have up to 20% ownership equity in all 150 of those license types, all those dispensaries. Once you go above 20%, or you start talking about, additional MSAs or seats on the board, it becomes more complicated. You might become a TPI, but, you can own 20% up of any license type in its given tier. So that was something that we wanted to create to increase the flexibility and access for investment. I'll stop there and turn it over Fatima, and I can take some questions later.
Thank you very much. So Fatima, I'm just going to prompt you. So I think the first thing we were going to go into is the Social and Economic Equity Program. Could you give us a little bit of an overview of, because these regulations are very long and it's a lot to put on Damien to explain them all in a 10-minute.
282 pages, I agree. So I'm going to refer to the Social and Economic Equity Program throughout this webinar as SEIA, just for shorthand. So for SEIA, there are 5 different categories in which you can qualify as a SEIA applicant under Section 121.1 of the proposed regulations as they're currently written. There is a social and economic equity program application opportunity for individuals who either reside in a community that's been disproportionately impacted by cannabis prohibition. In terms of what a community that's been disproportionately impacted by cannabis prohibition means, the OCM, and Damien can, fill in later about this, but OCM is still yet to actually create the list of these communities and designate them. But under the proposed regulations, what OCM can utilize in terms of factors in coming up with that list are things such as arrest and conviction rates, median household income levels, deportation records, a number of children that have been taken from their parents by ACS because of cannabis use or a conviction or arrest record, high school graduation rates, and unemployment. So there are a number of factors there that can all be taken into consideration as OCM creates this list, which I'm sure will be coming out in the next few months. So that way applicants can get themselves ready and decide and determine whether or not they qualify somebody who lives in one of those areas. Minority-owned business is another category of prioritization under the SEIA program. So to be a minority-owned business, you have to have 51% ownership in the business, have sole control, has to be a small business, and a minority member is defined as being either Black or African American, Hispanic or Latin heritage, Asian or Pacific Islander, or Native American or Alaskan Native. And you can either, what's interesting about what New York is doing is it gives you the option of either getting certified through the state as a minority woman business enterprise or self-certification through a sworn statement. So definitely some flexibility there. Similarly, for a woman-owned business, which is the third category for SEIA, you would have to be a small business, also can either certify as an MWBE through the state or self-certify through a sworn statement. And you also have to be 51% owned by one or more women who have sole control of the company. Our last 2 sections are distressed farmers. So one or more members with sole control have to meet the small farm classification as developed by the Economic Research Service of the United States Department of Agriculture. You would also need to file a Schedule F tax return, and you also would have to file another type of tax form that demonstrates that your revenue as a farmer is below the qualifying threshold. And then our 5th category for SEIA would be service disabled veteran-owned businesses. And in order to demonstrate that, you would have to submit a certification from the New York State Office of General Services Division of Service Disabled Veterans Business Development. Or you can also, if you don't have that certification yet, OCM will give you a 60-day period where you can get a conditional certification by submitting any VA documentation that shows your service-connected disability rating. And you'll have 60 days to then complete your application and get the certification through the business development division. So in addition to those 5 separate categories for eligibility for SEIA, there's also extra priority that is given to anyone who resides in a community that's been disproportionately impacted by cannabis prohibition, also has an income that's lower than 80% of the median income of the county in which they reside, and also has a conviction of a cannabis offense prior to the effective date of the regulations, or in addition, separately from having their own conviction, they could also be the parent, guardian, child, spouse, or dependent of somebody who has a cannabis conviction. So that is really a general overview of who qualifies. In terms of the benefits, Damien sort of alluded to some of the benefits, which would include prioritization of your application review, license issuance. And there's also, of course, the benefit that Damien also mentioned before about reduced fees for your licensing and application fees, or potentially having them completely waived or deferred. And then there's also mention in the proposed regulations about an incubator program, which we don't have a lot of detail about yet. But one of the nice things about what we do know is that if you were to have your license denied, but you are otherwise eligible for a license and you qualify as a SIA applicant, you can elect to participate in the incubator program, depending on if you are approved. But if you do approve for the incubator program, you can participate in that and then reapply. Whereas if you weren't a SIA applicant, you'd have to wait at least a year if you were denied a license. So some nice little benefits there. There might also be some funding, grants, loans to help, some mentorship, potential there. So, the SIA program is definitely something that is going to be very beneficial to communities who've been disproportionately harmed by the war on drugs, to, women and minority-owned businesses. We know what the, barriers to entry have been for all these various businesses, and distressed farmers and, service-disabled veterans who do not always actually get taken into consideration in social equity programs in other states that have legalized. So New York is really trying, their hardest to put social equity at the front and center. And, I'm really proud to be from the state.
Awesome. Thank you. So one question I have, but I'm not sure that it's actually, there's that much guidance in the regulations. Do we have a sense of which of these social equity groups will be prioritized with the first applications?
Yes, the MRTA lays out extra priority for those individuals with marijuana arrest and are from a community disproportionately impacted. The second level of prioritization is individuals from a community disproportionately impacted. And the third and fourth, we go into service disabled veterans, distressed farmers, and then everybody else.
Okay. So are we looking at different earlier in time applications for those prioritized groups, or just priority review according to their applications?
A mix of both. I think that the regs, honestly are giving us a lot of pathways to doing all of that at the same time. And I think that for folks to understand, we're going through a lot of this right now with CARD, where our licensing team is, working with our IT and some of our contractors to score those. We're expecting tens of thousands of applications next year. And so, over the course of the next 6 months, we're going to be building out the internal systems to really take that on. And so there will be a mix of prioritization for review, prioritization for issuance. There will also be bucketing, potentially scoring applicants together based on their category, so they're not scored in with everybody else. There'll be a mix of all of that to achieve our equity outcomes.
Awesome. And just for our listeners, the CARD program that Damon refers to is the conditional retailer license. The application period was back in August to September, so that's closed. Do we have any rough idea of when licensing will open up for the general public?
Next summer.
Okay.
July, ideally.
Great. Now, Osbert, I want to turn it over to you to talk a bit about the distinction that's made in these regulations for veteran-owned businesses versus service-disabled veteran-owned businesses.
Sure. So little history on, service-disabled veterans and the distinction, right, between veteran and service-disabled veteran. So veteran is a person that has served and received an honorable discharge from any of the military branches. A service-disabled veteran is a person who, during the course of their military service, at some point received some type of injury or developed some type of condition, much like you've heard about recently in the news, burn pits and, veterans developing all types of respiratory issues because of their exposures to burn pits in foreign combat zones. And so, again, a person either received an injury or developed an injury as a result of their service. And then through the Department of Veterans Affairs at the federal level, they received a distinction of being a service-disabled veteran. They receive a rating that makes them a service-disabled veteran, anywhere from 10%, actually from 0%. The government can say that your condition is attributable to your service, but you're not going to receive any compensation. So it goes anywhere from 0 to 100%. The distinction is the MRTA specifically lays out and identifies service-disabled veteran-owned businesses as, like Damien just covered, one of the different tiers of priority applicants. Unique to the service-disabled veteran community is that we are neither gender or race-specific. On the contrary, we incorporate the entire diaspora of the population. So every race, gender, religion, creed, sexual orientation, service-disabled veterans make up all of those different communities. And so we're very different segment when it comes to looking at socioeconomic programs and socioeconomic distinctions. Within the regulations and conversation that's been had, and it'll be part of our comment, is the need to just maintain the separation of and identification of veterans and service-disabled veterans, because ultimately they are two different groups. And service-disabled veterans, as persons who are actually disabled and have a disability, are also a protected class in the eyes of the federal government. And so it's an important distinction that needs to be recognized.
Absolutely. So is there any prioritization for veteran-owned businesses that are not service-disabled?
So if I could just give an explanation on the Service Disabled Veteran Program. Article 17B was passed several years ago, and that is the program that created within the Office of General Services the Division of Service Disabled Veteran-Owned Businesses. And so a person seeking to be certified as a SDVOB, which is the acronym Service Disabled Veteran-Owned Business, as an SDVOB, has to go and submit all of their company paperwork, et cetera, proof and documentation that they were at the minimum 51% owner and operate and manage the day-to-day and long-term operations of that entity in order to receive their service disabled veteran-owned business designation. And so that's an important piece of that, because within 17B, there is nothing that at this point in time identifies any type of socioeconomic preference for veteran-owned businesses specifically. At the federal level, there's the VOB program and the SDVOSB program, but at the state level, there currently isn't, and neither does that exist in any other state that has a service disabled veteran-owned program.
Great. Well, many Latinos do serve in the armed services in this country, and so this is an important program that is real source of priority for our community. So it's good. I'm glad you're bringing it up. So I want to transition here and hopefully address some of the comments that are coming in to the guidance that was recently issued by the OCM for delivery for the card licenses. Now, of course, card being conditional retailers, because it's the first retail license being opened up. We're definitely hitting some roadblocks, including a lawsuit and difficulty finding real estate, which is a problem for cannabis programs in every state. So we're looking at having these retailers be able to operate, find their own location or operate a delivery only location for a year. Is that accurate, Damien? Please jump in if I'm way off base here.
No, I won't speak to much of the details because we're still working them out with DASNY. DASNY is obviously still securing leases, and there will be some flexibility in the future about potentially finding their own location. But for right now, we're focused on locking in those leases with DASNY and assisting our card licensees to get some revenue coming in the door with these offsite delivery locations as well. And they'll have that for 12 months once they've started it. So they can actually operate that offsite delivery location while they're setting up their brick and mortar at the same time, so they can continue to have revenue coming in.
Okay, awesome. And the card licensees, if they are going to look for their own location in the meantime, they are limited to the region where for which they're selected, correct?
Yeah, well, that's still being worked out. With DASNY, they will not be permitted to move regions.
Okay, yeah, we had a question on that. So you cannot change regions, it sounds like. So what I want to segue into and get Fatima and Osbert, the group's thoughts on, is when you open a delivery only location or you open a retail location, you have to find a municipality that is willing to have you, because municipalities are able to opt out of retail. They can't opt out of cultivation or processing, which is great, but they can opt out of retail. And if they've opted in, you're still subject to municipal zoning. And that goes for a delivery location as well. And this is difficult, no doubt, but I want to draw a comparison to what is happening across the river in New Jersey, where municipal restrictions make it nigh on impossible to get operational and get local approval, because towns are able to have their own licensing structure and very, very restrictive zoning and rules on this. So this is one area where New York actually has lower barriers to entry than some other places.
Yeah, absolutely. I have a number of clients who have their conditional licenses in Jersey that are, still trying to get through all of the municipal hoops. There are municipalities that have have entire licensing application processes that are separate from the state's licensing application process. And in order to get your state license, you obviously need to demonstrate that you have municipal approval. So now many of these clients who are, social equity applicants who've gotten their conditional license because the conditional license is supposed to be lowering barriers to entry, but they only have a limited period of time in which to convert to a standard license. And so they now have to go through this entire municipal process, depending on where they're applying. Most of these municipal processes are unclear, expensive, time consuming, and complicated, right? So especially if you're working with counsel who may not be actually from Jersey, you now have to get local Jersey counsel, because whenever you're dealing with these municipality issues in particular, you never want to bring an out-of-state lawyer, right? That's like the worst thing you could possibly do. Municipalities do not like that. And so now you've got these, clients who often already are at a disadvantage financially, who now have to have these large legal teams just to get them through something that was supposed to be an incredibly low barrier to entry, so that they didn't have to, demonstrate all the things that typically are demonstrated in very comprehensive application processes. And now they have to go through two. And that doesn't even include zoning. There's the municipal process, which is separate from your zoning approval. So I think what New York is doing in terms of limiting the discretion of municipalities and only allowing municipalities to have control over time, manner, and place restrictions is incredibly important. It is a huge barrier to entry that has been lowered. And I'm really, really, looking forward to it. Obviously, that doesn't mean that there's going to be no barriers, right? Because New York City in particular is known for its overzealous regulations when it comes to zoning. And so while there may not be any restrictions that are permitted outside of time, place, and manner, when it comes to zoning restrictions, that, you can essentially zone people out of the business in your area. So we need to be really mindful and careful about that and watch how these zoning restrictions play out in various municipalities across the state.
If I could just jump in there, I mean, you've already, again, to Fatima's point, in New Jersey, the process is definitely has additional challenges at the municipal level. For example, you have to get zoning approval, you have to get planning board approval. A lot of the municipalities have their own quote unquote cannabis control board or body. And then you have to go to the city council and secure from the city council ultimately a resolution from the governing body that then needs to be transmitted to the state to show that you have municipal approval. One thing that we're leaving out in this conversation is the amount of money that you're expending, because at that point you need site control, which means now you have a location you're paying rent on, you're paying insurance on, you have an architect, an engineer, et cetera, security professionals that have all collaborated on this plan, which is presented to the planning and zoning department. They review it, they approve it. The cannabis control board of that town or municipality reviews it and approves it, and then it goes to the city council. And so during that time frame, you're expending capital. And so New York is getting it right in that regard with providing a different pathway that does not front load the process. The problem with time, place, and manner is in New York is that you see municipalities on Long Island in communities upstate where they're literally opting out by zoning out, and they're creating under the guise of time, place, and manner restrictions that are overly burdensome. You can't be within 1 mile of another dispensary. You can't be within X amount of feet of a gathering place, which is a firehouse, a batting cage, a bowling alley, anywhere where people congregate. And so those types of restrictions elevate and create an undue burden when it comes to time, place, and manner. And so while they may say, yes, we're the town of ABC and we are open to cannabis, but you can only be in a light industrial or heavy industrial area, which means like next to the garbage dump, next to the asphalt processing plant, or like I just said, in one of these areas that are quote unquote light industrial, but there are multiple layers of community gathering places. And so, and then on top of that, they say, and you can't be within a mile of another place. Well, how are you supposed to know that someone a mile away is trying to undertake the same process that you are, because it's all private and confidential? So those types of problems are the ones that raise to the level of creating an undue burden for small business applicants.
And these time, place, and manner restrictions are going to apply to all license types. I don't see a way that cultivators or manufacturers avoid having to get zoning approval for opening up. Like, sure, towns can't exclude them, but they still have to get fire inspection, right?
With the growers, because it's categorized as an agricultural commodity, they're actually, if it's zoned agricultural, there's nothing zoning they'll need. I think it gets a little more complicated with zoned industrial.
Yeah, the problem with dispensaries is when you look at these regulations that some of these towns have taken on Long Island, because Nassau County on Long Island, for example, is a complete no-go zone. The entirety of the county has opted out. But for certain municipalities on Long Island, certain municipalities, upstate, that's the problem, right? Where the restrictions or those overly burdensome and unduly burdensome restrictions are actually just on the retail component. And so, whereas, folks will say, well, if the regulatory process is akin to the Alcohol Beverage Control Act that exists and regulations that exist in New York, then how come a cannabis business that is properly licensed? Well, why can't it be in the same type of commercial retail environment as a liquor store or a bar or any place that carries alcohol? So the fact that these businesses are being segregated to light industrial, heavy industrial areas, that's the distinction of what unduly.
Yeah. And I'll say that we're not going to let that happen. Like, if you opted into dispensaries, you cannot say that they have to be in your industrial zone. Like, and first and foremost, if we're putting equity first, that means that our equity retailers are going to be put into those zones. And then in the future, when the stigma fades and they've seen all the tax dollars come into their community, that the future licensees are going to be put in the commercial, like it can't happen. And so, we have language in our regulations prohibiting people from, passing, local municipal zoning laws like that seek to segregate the cannabis business from other businesses. And I'll say that, the opt-out and opt-in was a very important thing that we needed to do to get everyone on board with what we're about to do. But the opt-in is always going to be there for those communities. And we fully expect, and we're in conversations with a lot of communities in Long Island that will come back on board as they see the type of industry that we're rolling out that incorporates family farms, is, a lot of testing standards, public health requirements, and locals from their community actually owning the businesses. Because ultimately, they're denying their residents the opportunities in some cases. And when they start seeing, residents in neighboring counties and municipalities taking advantage of these opportunities and making some money, reinvesting in their communities, I expect a lot of them will come back to the table to opt in.
And you know what, along those lines too, for those that are on Long Island that are, dealing with SALT, with, having to pay these and unable to deduct, these high threshold property taxes and stuff like that, the funds that will come back into the community because of cannabis taxes, that's a potential ability for the municipality to redirect some of those funds to help lower your school taxes, your property taxes, et cetera. So, if you're from Long Island, if you're from an area where SALT is impacting you as a homeowner, read up and get educated on it, because it's super important for you to advocate to your elected officials, not only at the state level, so they can empower the OCM to do what they need to do to prevent and prohibit these overly burdensome restrictions on small businesses, mom and pop businesses, but also for your local elected officials to take a progressive stance when it comes to creating a cannabis market that's going to be fair and equitable and contribute to the local economy to lower your taxes, your personal taxes, your school taxes as well.
And to add to Osbert and Damien's points, municipalities can always opt in as the way that the MRTA has been structured. So as you know, we're sitting here talking about all these potential issues with municipalities and their zoning restrictions, you know, it's really incumbent upon each and every one of us in this space, including potential applicants and operators, to really get involved in their communities. You know, educate your officials, because that's like one of the first things I ever talk to a client about when they're looking to apply for a license. I tell them they need to show up at every board meeting. They need to make their faces known. They need to make themselves heard. And they need to educate the officials on why it is that cannabis is not the scary boogeyman that they think it is. Why, you know, bringing cannabis business into that community will actually add value to it. It will not be a detriment to it. You know, a lot of municipalities are still behind the ball in terms of conservative politics, and a lot of, you know, scary talking points that they've been hearing over and over again about danger to children, all these, you know, things that we know are ridiculous, but it really takes a certain level of education and patience to get through to them. And I do think that we can change hearts and minds. I just think it's going to be, you know, a constant concerted effort among everybody who wants this space to succeed. We're all going to have to do our part. And so I just wanted to, you know, throw that in there.
And
that's fantastic advice. Like, if not, no matter what, you need the support of your neighbors and the town where you're operating, because they can make your life hell.
Yeah, that's the other thing, you know, even forgetting about municipal laws and ordinances and restrictions, you want your local neighbors to like you, because even if there's nothing that can be done to you, you know, by ordinance or law or restriction in terms of zoning, you don't want to have a neighbor who makes your life living hell, as Jen just put out. You know, not in my backyard lawsuits. We've been seeing them all over the country, and those aren't going to necessarily end. But if you show that you're a good neighbor, that, you know, you're looking to really add value, like I mentioned before, you're going to have a lot less of an obstacle when it comes to, you know, having a great relationship with all of your neighbors.
And if you're an elected official that's listening to this into this webinar, one thing to also realize is, under the MRTA, anyone operating in the cannabis space has to sign a labor peace agreement. And that labor peace agreement allows the unions to have the opportunity to organize your workforce. And so that creates an opportunity for something that really doesn't exist, which are the opportunity for the workers to decide whether they want to unionize or not. I can say that personally at the Cannabis Place, we are launching the first dispensary to ever launch as a union shop ever in the country, which means that we're, you know, the cannabis industry is now bringing, like we are, bringing actual cannabis careers to the communities that actually are bringing true economic empowerment and true economic viability to communities that normally would not have it, because there's a major disinvestment in local communities. You know, there's plenty of opportunities in let's say metropolitan areas, but your local communities don't have a fountain of new jobs coming in that are potentially going to be union jobs with, you know, benefits and higher paying wages, et cetera, that are going to enhance your local economy, in addition to the dollars that are going to come in from the tax revenue to the local community.
Great point. So everyone reach out to Saul at UFCW, because you need him to be a friend. All right. So good guy. All right, moving on, because it's now I'm seeing 2:46, and there is a big topic that we're getting questions on, and I think that people, the concept of the TPI, the true party of interest. Damien, your slides were incredibly helpful on this topic, and one question that I'm seeing in the comments that I have is, can you avoid being a TPI if you're a passive investor, if you fall under that 5% or 20% threshold?
Yeah, you can. I think I saw the question as well. You can do both. So you can be a TPI in 3 retail licenses and also be a passive investor in other retail licenses. But they would all have to be within one tier. You couldn't cross the tiers.
Okay.
Yeah.
Okay. How about, because there is a restriction in the proposed regulations on being in a TPI with a retail license in New York, if you have any involvement with the cultivation or processing or distribution tiers in New York or anywhere else in the country.
Yep.
How about if you have an interest in cultivation in another state? Could you be a passive investor with a retailer in New York?
No. And yeah, it's a good question. And I just want to paint one scenario for folks to understand why that restriction is there, because a lot of people are frustrated by it. first and foremost, we want our retailers to be fully independent and autonomous of any undue influence so they can actually have the freedom to put the best products on their shelves and nothing else. The second thing is interstate commerce is inevitable. It's coming, and our industry that we're building is going to be ready for that. And so if there's a scenario where someone who is a vertically integrated company also has dispensaries in, let's say, Manhattan, they might start locating their cultivation and manufacturing facilities in Jersey, in Pennsylvania, on the borders with New York. The second the walls come down, they have a vertically integrated business with a dispensary in Manhattan, while our producers that were in the state of New York have no access to doing that same thing. And so it would actually be, very unfair to businesses that started in New York, and it would just violate our vertical integration stopgap. So that's ultimately why that restriction is there. I know it's frustrating to some, but all businesses vertically integrated are able to participate in our market on the supply side. And if you just have retail licenses in other states, you can also have retail licenses here.
Okay, what I'm seeing with some groups is we'll have New York-based groups often that went ahead and got licenses in other states, because for a long time, New York just didn't have a program, and it's now 2022. And Massachusetts, for instance, has had a legal program for a while. Colorado, other states have. The whole Northeast is getting them. I'm wondering if the OCM is open to an idea of maybe having a threshold of how big of a cultivation you have in another size, or if you're only in one other state, or is it just a blanket restriction on this topic?
Blanket restriction. The integrity of the two-tier system is too important to make carve-outs, because the carve-outs would lead to wider carve-outs and wider carve-outs, and we might as well just have a vertically integrated market at that point. And that's not what the MRTA is. I think if folks want us to have a vertically integrated market, they need to talk to their assemblymen and state senators, because the MRTA would have to be dramatically changed.
All right. Anyone else? Topics on this point or questions from the audience?
Well, I would just say that we should also keep in mind that there is one exception to the vertical integration prohibition, and that is the microbusiness license. And I think that's an incredibly important license, particularly for social and economic equity applicants, because the barriers to entry are much lower to getting that license type.
Absolutely. And that is a license that is intended for social and economic equity applicants. So I'm overseeing that license. I plan to license hundreds, if not 1,000 of those things over the next 3 to 5 years. I think that's an incredible license, a great way to enter the market. We've also created language in there that says that micro business operators can do on-site consumption, they can do delivery, they can sell clones. They can also, if they're reach their capacity with 3,500 square foot indoor, they could transition to a full indoor cultivation license and just do that. Or they could leave the micro business and license their brand that was maybe popular in Manhattan and partner with another grower to do the brand. So there's a lot of flexibility to that micro business license. And that's why it's going to be really ideal for social and economic equity applicants.
That's a very exciting license type.
One because I don't know
question I have is the restriction on, sorry, Fatima, I'll turn it over to you just 1 second. The restriction on being able to buy wholesale unless you have a total crop failure.
Yeah.
That is a very challenging one if you're new to cultivation, for instance, because that's I wouldn't try cultivating weed, and I like weed. I have some experience with it. But
yeah, it's
I don't know
tricky.
that I want to take that on.
So I think that, they're going to have this ability first to have, their retail location away from their production site, so they can actually have their production site in a different real estate location cheaper. But they're also going to be able to brand and sell their own products. And so the way I'm envisioning this working, like you will have your local weed guy in Williamsburg, Brooklyn could have, a grow and processing manufacturing place 20 miles away. And that's the brand that community likes to go buy from. So you have that D2C access that no other producer is going to have. So there are a lot of advantages with the license, like a winery or a craft brewery, but also with on-site consumption. So there's a lot of different revenue streams that this business could develop. And so we thought that also letting them wholesale for other producers would just be too much of an operational advantage over our other producers.
Hima?
Oh, I was just getting excited about the micro business license, and just, thinking about how I haven't really seen that level of flexibility with that license type in other states where they do have micro business licenses. And so I do think that's going to be a really great opportunity for, SIA applicants. And actually, I kind of have a question for you, Damien. Feel free to not answer it. But how did they come to the 3,000 square foot canopy limit?
3,500?
The 3,500. Yes, I'm sorry.
Yeah, we have a guy who works here who comes from a cannabis hedge fund VC, and he runs numbers, and we're just trying to make sure that this is a profitable business to run. How much revenue would it do with 3,500 square foot indoor if they were doing perpetual grow, and going direct to consumer? And it's a profitable business. It makes money, especially if they have a popular brand and they can sell more high-end cannabis products directly to the consumer. That paired with the on-site consumption and with the ability to do delivery, we think that it's going to be a multi-million-dollar business, even though it's got that small canopy square footage.
Love to.
The other thing I want to, because we are running up on time, and I think that there is another license type that has yet to come out that I think that this community will be very excited about. We took our time with it because we actually really want it to be great, and that is the on-site consumption license. So all dispensaries, retailers will be able to have on-site consumption locations, like a lounge next to their retail location. That's of course going to happen. But when we were looking at the on-site consumption standalone license, we were having trouble thinking of ways to make it a profitable business for people who just wanted to come in and could only smoke or consume whatever was on site. And so the new direction we're heading in with the on-site consumption license is it's going to be more of a registration for events, museums, movie theaters, restaurants, and other businesses to pair existing business activities that they're doing with an on-site consumption option. That way, we think that we can really, tap into new markets with cannabis in ways that other states haven't before. We are even exploring ways that, you could have an on-site consumption license that isn't plant touching. You just basically create a space in your existing business where people can come and consume cannabis. And so there's just a lot of ways we're looking at on-site consumption that will, I think, for Black and brown communities, Hispanic communities, immigrant communities, will really be accessible and allow them to dabble in the cannabis space without going full-fledged into building out some huge facility, taking on all this debt, and allow them to incorporate it into their food, their cultural events, their music events. And so that license type, the regulations for that will be forthcoming, I think, early next year.
Damien, if I may.
That actually, sorry, go ahead, Oscar.
I was going to say, if I may, Damien, that's amazing. That doesn't exist anywhere else. So that is something that really transcends all barriers and really creates an opportunity for, like you said, the culture, right? For the culture to be able to exist anywhere across all spectrums. And, I look forward to seeing that, because that sounds awesome. That's really amazing.
Yeah, I think for the first time, you have people regulating the plant who really like cannabis.
That helps.
So that's where these policies are coming from.
Yeah,
That's a good point.
I do have a question, Damien, with regard to, if I may, white labeling. And I know kind of what the background stance is of the OCM. But I'd just like to give an example. Like, I go to a local restaurant, I go to my pizzeria, and, I can get a Grimaldi's water bottle. But they also have, other brands of water bottles for sale there. And so the reason that Grimaldi's or whatever, pick your pizzeria, no plug to Grimaldi's, I don't own any stock or anything like that. But the reason that you can do that is because it helps the small business to build name recognition, right? With a very simple, regular product that they get from, a bottler that puts their sticker on it and allows them to build consumer recognition within their local community. And so my question is, any thoughts on where potentially, quote unquote, white labeling can go? And when I say white labeling, it's a dispensary or a consumption lounge having a product that actually has its name on the packaging, but that is legally grown by a legal, cultivator or processor.
Yeah, so retailers won't be able to white label their own products, cannabis products. They will be able to sell merch with their brand on it. They will obviously be able to have on-site consumption, do delivery, We do want those brands to matter. We want stores to be known, like maybe it's a legacy branded chain of stores, because you can have up to 3 locations. And then we want them to be able to interact with their customers in a way that like they trust with the brands they're selling there. But that full autonomy, independent autonomy of like getting the best products on their shelves, it kind of disappears if they're also able to put their own products on their shelves, because that's ultimately what they'll just end up doing. It's what we watched other states to learn this. It's especially as the margins get thinner, they will look for other ways to make more money, and that involves selling their own stuff. And that will make it very difficult for growers and producers outside of the retail space to get products on shelves. Then those companies will start losing money. Then they'll start probably driving that stuff to the illicit market. Like, it's just a cycle that will happen. As soon as that shelf space gets compromised with stuff and it becomes unavailable to the growers and producers outside of the retail space, the market falls apart. That's sort of what's happening in California. It's also happening in Michigan right now.
What about collabos, like again, a dispensary or a consumption lounge doing a collabo with a,
Yeah, we are looking at ways for dispensaries to do pop-up events like farmers markets, and other, revenue generating, like partnering with an on-site consumption license at an event to sell their stuff at a concert, maybe. We're trying to figure out ways for them to be more flexible and have other revenue streams. But yeah, that's it. The only thing that we're sure they can't do is put their own products on the shelves.
Well, we're just about out of time, so I just want to address like 2 questions here. So first of all, just confirming, I heard Damien say that the next application process isn't expected until July 2023. Is that correct?
Correct. And that is, I saw the question too. There's a prescribed legal thing that needs to happen now. There's basically 100 days of public comment before we can finally stamp the regulations. It's done in final, and we have to read 1,000 public comments, incorporate changes. And so we expect to stamp those regulations, and those are the final regulations for the industry in April or at the latest May. And then, as we're doing that, we're creating this, universal application system where people will be able to apply and roll that over the summer.
So we're done with Business Express.
Yeah.
Oh my God. All right, cool. Daisy, you've been silent. Any last words?
I do. I just have a question for Damien while I have his undivided attention here. I'm just curious to know what, if anything, the OCM and New York State is doing to help these licensees, these license holders, with regard to safe banking and how they're holding their capital, what they're doing with the capital. Is there anything, is there a roadmap in place? Is New York State planning to subsidize a bank for license holders?
Yeah, I'll give you an example of something that my team is working on right now. There's a program we're developing that will see us partner with credit unions in New York State, where we will either underwrite or be the loan provider. We'll back up the risk of the loan to ensure that our social equity applicants can have access to loans from credit unions that are at reasonable interest rates. We'll take on a lot of that risk with our fund, and that way the banks can deploy capital at better interest rates quicker and faster. That's like an example of a program that we're working on now. I think that capital is going to be the biggest impediment for social equity applicants, especially given the market conditions. And so we are going to be hitting the streets, talking to investors who have never invested in cannabis, family funds, foundations. The city of New York will probably get involved as well, and other municipalities. And so it'll be an all hands on deck thing to make sure that capital is deployed for these operators.
That sounds amazing. Do you have a timeline as to when that might launch?
Next year, like towards the end of like a year from now, basically, because, we roll out those applications in summer and start licensing people towards August, and then hopefully be able, and again, I don't know if people know this, in the regs, if you get a license as a social and economic equity applicant, you have 12 months to open your door, and you can also apply for extensions. So while you'll get the license to go out, raise the money, look for the real estate, we'll give you 12 months to just do that. And we'll be able to sort of come in and help you if you're not, if you're having trouble with it, I guess.
Right. Well, we're now 2 minutes past 3 o'clock, and mindful of everyone's time. Thank you so much, everybody, for joining today. Any final parting thoughts before I sign off?
I have one. So I'd like to, for those that are on the webinar right now, and maybe you're looking to build your cannabis knowledge. Maybe you're looking to, get more information on a particular area within cannabis. Cornell University, the Workforce Diversity Initiative, they have partnered, they've created what's the Cannabis Workforce Initiative, cannabisworkforceinitiative.com. Totally free training modules are currently up and online, self-paced. They're going to be actually coming out with some other modules as well related to training with interactive webinar training as well. And so if you're looking to build your knowledge, save your money, go check out cannabisworkforceinitiative.com and get that premier training and education and knowledge base for free from Cornell University and the WDI and New York State as well. And so it's a great opportunity.
All right. Well, sorry.
Thank you, everybody. I just said the next round of card licenses will be coming before Christmas. I have to drop now because I'm late for a meeting, but thank you.
All right.
Appreciate
Thank you, everyone,
it.
for coming, and
Thank you so much,
happy
Stevie.
holidays all.
Happy
Thank
holidays
you.
all.
Holidays.
Thank
Take
you.
care. Bye. All right. Well, great work, everyone. Thank you.
Thank you so much.
And
Happy holidays.
yeah.